bundles, and if I can just finish off the point on that and then start on the
supplementary one.
We were in supplementary one, and we can take it from there actually, but there's just an easier reference in supplementary bundle 2, which is probably worth looking at, just to tell my lords, my ladies, where the point is going, is that these, if one adopts the approach, which we say is the right approach, which is to look at each of the individual apps individually to see whether there is infringement and each of the individual appearances of the relevant mark, one does then need to consider, indeed following the debate between my learned friend and the court about well-known marks and so on, exactly what marks it is said should have been identified, bearing in mind the significant range with which we are dealing with here. The judge, as you have seen, made findings in relation to certain marks which were, as it were, major brands. But we're not dealing in this case only with, as it were, some popular brands. We're dealing with situations where there was a small number of downloads of watch brands that I would respectfully say were obscure, and in a sense we know that they were obscure, because I think even my learned friend in opening the case to the judge said I hadn't heard of some of these brands.
Indeed, I think that's a very fair point, but I think you accept that some of them were well known. And how are we to differentiate between the two classes?
I'll come on to that in relation to my submissions on Article 14, because the solution that we recommend as to interpretation and approach to that legislation doesn't mean that one needs to differentiate between them.
Because you say you can ignore what's well known.
It is not that one can ignore what is well known. That is not my submission. My submission is that unless what is in trademark parlance described, for example, as well known, is in fact known, and I'll just briefly go back to the authority in relation to that, there's no basis for imputing knowledge of a well-known trademark. And part of the reason for that is because it is not even clear, I don't have all of the authorities immediately to hand, but some of the members of the court will be aware of this. It's not always clear that every court would take the same view as to whether a given mark was well known, or indeed apply exactly the same standards to whether a mark was a well-known mark, whether it be evidentially or legally, even though it may be a term that is used, including a term in international conventions. But the reason I make this point at the outset is because it highlights an issue with construing the legislation, both in the form of the directive and the implementation, as saying, which may lie behind my Lord's line of questioning, a undertaking is deemed to know well-known marks, and therefore, if they are deemed to know well-known marks, then they satisfy the second limb of the test, in that they then have the information relating to the relevant mark before them.
To know them, it's that well-known marks are in fact well known.
Indeed, well-known marks are in fact well known, but may not in fact be known by given undertakings in given parts of the world.
But then the question is, who are you talking about? I mean, an individual software engineer just out of university in Vietnam may not know a well-known trademark, but the company by whom he is employed, who's a multinational with operations across the globe, may well for sure know that.
My lord, and that may be so, in that there may be one or more individuals in the undertaking who know a mark. But my point is more fundamental than that, which is that if one goes down that route of saying that there are categories of rights which are, for one reason or another, taken to be known by a person in a relevant undertaking, whether or not they're actually involved in the relevant process, which is, I think, the starting point of my Lord's analysis, then the consequence for that would be to say, well, there is an obligation on the part of the undertaking to monitor well-known marks.
Well, we have to break this down a bit. Part of the point that my lord was putting to you is that we're not concerned with the knowledge of any particular individual. We're concerned with the knowledge of the undertaking. And what the undertaking knows, unless there's some European principle to the contrary, would be decided by the rules of attribution. So one question would be, what did Samsung know? Not what did the particular reviewer know? Your second point is, if Samsung didn't know, then knowledge should not be attributed to Samsung, and that's a different point.
Indeed.
So you've got as it were, an internal attribution point, which I think you accept would apply to any corporate undertaking.
It may do on this basis that if one thinks of large internet or online companies, it's probably quite difficult to find one which doesn't have one or more employees.
Yeah.
Who are formally speaking agents of the company.
Yes.
Who might know of one or more well-known marks.
So you've got an internal attribution question, and so to speak, an external attribution question.
My lord,
and I think what you're cavilling at is not the internal attribution question, but the external attribution question.
I'm perhaps not cavilling at the internal attribution question as a matter of, in some senses, common sense, that there will be someone in these undertakings who, let's take it even away from the facts of this case, there will be someone in eBay who has heard of L'Oreal. This is, one must take that for granted. Or any, in some sense, popular brand. There will be someone who knows it. And so to that extent, internal attribution of popularity is inevitable. The reason that I make this point up front with reference to this case is because the facts of this case and the different nature of the brands illustrates the difficulty if one goes down that route, both on the internal attribution argument and on the external attribution argument. And the reason that it matters on the internal attribution argument is this. If one says, well, because someone is bound to know in an undertaking, and then because of that, no one is entitled to the defense if something gets through, there are actually possibly even two consequences that follow from that. First, that the defense will, for practical purposes, never apply, because you can always find someone who knows, and therefore the test of actual awareness, actual knowledge or awareness would simply not be a test of knowledge or awareness of illegality at all. What it would be a test of is whether or not the brand was well known, and it was therefore on that basis to be assumed that there was someone in the undertaking who knew it, from which the corollary flowed that the undertaking was deemed to know it as a whole.
But the awareness or knowledge referred to in the directive must it not be the knowledge of the operator?
Oh, indeed.
Not a particular individual within the operator.
I accept that. All I'm saying is that if one goes down that route, the argument does have quite radical consequences, because in undertakings which may have, whatever, 40,000 employees, if you, as it were, take the knowledge in the head of all of those employees, attribute it to the undertaking on the basis that it is therefore to be attributed.
Yeah, but you wouldn't necessarily do that. It would depend. I mean, people have private knowledge, which is not part of their corporate duty. I mean, somebody may know the names of all the members of the Arsenal football team, but you don't necessarily say that that's known to the company.
No, indeed, and I'm not putting it in that way. But let's suppose, for example, just to take this case as an example, that someone in the in fact, perhaps in this case is not such a good example. Take the eBay case as an example. Someone had gone to eBay saying, would you like to sell a particular physical watch? And let's suppose it was a relatively obscure brand of watch. I mean, in the official corporate capacity. Then one might say, well, the knowledge is attributed to eBay of that watch, watch brand. Does it follow thereafter that eBay, knowing of the existence of that watch brand, because it's attributed as corporate knowledge in its internal capacity, would therefore be deemed to know of the relevant trademark for, it could be a completely new brand of watch, and therefore its searching department would then be obliged to search. And it's only those consequences that I'm seeking to develop, because the point that my Lord Justice Arnold put to me is a point of the same genus as paragraph 226 of the judgment that we criticize, where it says, well, all right, should the court be, it's not so much setting rules, but setting particular standards of the kinds and nature of mark that should have been picked up in a relevant process.
But this is not a debate about standards, this is a debate about knowledge. And you make the comparison with the L'Oreal and eBay case, and in many ways that's quite a telling contrast. So one has to stand back and remember what the alleged infringement of that case, because of course the majority of the goods being sold on the eBay site were perfectly legitimate goods, and there was no complaint about the legitimate goods being sold on the eBay site. There were three types of infringements. There were the outright counterfeits, and how was eBay supposed to know that they were counterfeits? Because it took quite a lot of investigation once you got the physical goods to determine that. Secondly, there were the grey goods. Well, that was a different story, because the way in which the eBay site actually made it pretty apparent that they were grey goods, because they were actively promoting the sale of stuff coming from the USA. Indeed. So that they did know as an organisation. And then there was the third category, which is the testers, which is a bit of a different issue. But if you think about the contrast between the counterfeits, how on earth were they supposed to know, and the grey goods, where they were actively promoting that trade, there's a big difference.
My lord, I entirely accept that point. The point is not, and I of course accept my lord's point as well, that this is a point about knowledge, and how knowledge should be, what knowledge should be attributed or taken to be had by a relevant undertaking. My point is that if one goes down that route of analysis, one is driven to the kind of thinking that my lord, in a sense, essentially was instantly driven to, which is to say, well, can we make a distinction here between well-known marks and other marks, on the basis that there is actually a distinction in law that's made in relation to that, and that well-known marks have certain legal incidence to them, quite apart from as a result of their being within the category of well-known marks. But then the question for this court would be, is the standard by reference to which Samsung's conduct should have been evaluated that which says it ought to have made itself more familiar at a particular level with well-known marks, even though it may have been reasonable for it not to familiarize itself with the other marks. The starting point, of course, for this was just drawing my lady's attention to the difference between the categories of marks, because while the argument may then have some purchase if it is accepted in relation to what would fall within the category of well-known marks, it would certainly not have purchase in relation to marks that were obscure marks. Indeed, one might say the very opposite was the case, that in relation to marks that were obscure, on no view could a diligent economic operator be expected to search for those marks, unless there was some very specific reason why it had been drawn to their attention that they should do. And if one is going down that route, in my submission, then there is a basis for saying, well, all right, the defense may apply to these goods but may not apply to those goods, just in the same way that the argument may apply differently in the two examples that my Lord Justice Arnold has given in relation to the eBay case, because there could be different scenarios. But you then need to look at it very, very individually. Our overall submission, though, is that that's not the right approach to looking at this kind of case, because the right approach is to look at what actual knowledge was had by certainly the relevant individuals, and to see whether they should have equipped themselves with, whether the law requires that they should have equipped themselves with additional knowledge. And we don't necessarily need to go to the document, but the basis for saying that there may be a distinction between these marks comes both from the judgment, where the judge goes through different kinds of marks and identifies the reputation.
And accepted that some of the marks are better known than others.
I don't want to labour that point, but the point is, if one's going down the let's look at this on a case-by-case basis, one has to look at, on a case-by-case basis, at what is reasonably
but the
to be
reality
expected.
is, I mean, theoretically, you're absolutely right. One could have a more granular analysis, but the reality is that neither side is inviting us to do that, or both sides are inviting us to apply an all-or-nothing approach.
Yes, but for very different reasons. In that the reason that we say that the approach applies to all is because of what we say the directive requires and does not require in this connection. The final point, before just going briefly to the authorities to draw a few of these threads together, is if one takes the approach that it is appropriate to undertake searching for, let's say, use the category well-known marks, present purposes. For reasons I explained yesterday, that doesn't always decide an infringement case, and I don't mean on the basis that marks may be invalidly registered or haven't paid the registration fee and so forth. There may well be issues in relation to what the mark is properly registered for, of the kind that identified with examples, restaurant marks and so forth. So one can't simply say, well, because someone has a mark, it is therefore right for products to be taken down bearing it. The Trigor Bassett example is actually quite a good example, because that's a football mark. Let's suppose that someone was doing a football app in which players appeared with Manchester United or whatever it was, kit. It wouldn't necessarily follow that that constituted an infringement, even though the mark Manchester United, I'm just taking that as an example, not to take Manchester United particularly because it was one mentioned here, would be an infringement in that context. And so the issue here is not only of is there visibility, but it is also of what the rights relate to. But I think I've made that point really.
Can I just pick up
times.
one point that you made, which I think I wrote down correctly? You said the right approach is to look at the actual knowledge of the relevant individuals, not to ask whether they should have equipped themselves with additional knowledge.
Yes.
So when you say the relevant individuals, you mean those employed in the particular department which is looking at content?
Insofar as those were, they were people who were engaged in.
Yeah. So that rules out what I've described as internal attribution.
Yes, that's our submission, and my point in relation to internal attribution is if you go down the route of internal, what might be called undertaking-wide internal attribution, which may.
So it means that if the information service provider chooses particularly ignorant people to look at his content, it's much safer than choosing knowledgeable people.
Well, we know that it's much safer not to have any people at all. yes, there are situations where one could assume that people are being completely cynical about a review and saying, well, I'm really just not going to, I'm going to give an illusion of review. That is not, in my respectful submission, a basis upon which one should, as it were, resolve a case or take an approach on interpretation. Yeah. Obviously, one doesn't want to interpret the law in such a way that it's easily evaded. That's axiomatic. But equally, one doesn't want to interpret the law on the basis that it is, the starting point will be that people are not going to undertake a proper review, or indeed, if it turns out that there is an issue with the review that they have undertaken or the way in which they've staffed it and so forth, that once the issue is raised, that they won't simply address it and say, okay, well, we need more people on the case. It doesn't mean they did it wrong previously. It can be improved over practice without someone having fundamentally erred in the first place. So that's the first point in answer to that. And the second point is, if one takes the approach of saying someone needs to search for well-known marks in order to satisfy 14.1a, and then also takes the approach that any form of searching, because it provides information about content, completely removes the availability of the defense in the first place. That is a point that we respectfully submit tells against interpreting the directive and the legislation as excluding that kind of activity, or making that kind of activity exclude the application of the regulation, because that would mean that the very circumstances that one would wish to encourage, and I know the court already has this point, are actually actively discouraged. Now, it's not just a question of encouragement and discouragement. It's also a question of where liability reasonably and fairly ought to lie in circumstances where someone has or has not done the relevant activity. And it may be the position going forward in the future may be different from that in the past. We're only looking at a past aspect. But we do say that is a matter that the court respectfully does need to take into consideration if it's thinking about purposive interpretation. And the point is put into sharp relief if one follows the thinking that lies behind the question of Lord Justice Arnold in the first place. So that's our submission in relation to that. Could I just briefly respond to the should point?
You wanted us to look at something in the supplementary bundle.
Oh, I think really I've just drawn your lordship's attention to it just because it's a convenient aide-memoire or summary. It was in supplementary bundle S2. There is a list of the marks in issue. I'll put mine away with the numbers of downloads and so on, and the various brands. I'm not sure.
Is this different to what's in the judge's appendices?
I'm not sure it really adds anything to the judge's appendices, actually. So, in any event, you've got the point about the difference in them. So, could we then just briefly take it up in L'Oreal? That's Joint Authorities 3 at 760. And perhaps I could just deal with both of the points on respondent's notice and on Article 14.1a together, so we don't have to keep going backwards and forwards. So we take it up at paragraph 113, merely technical and automatic pressing. I'm sorry, I'm going a little bit too quickly. That's not the case with the service provider. Instead of confining itself to providing that service neutrally by merely technical and automatic pressing, the data provides that customer trading app control such kind as to give it knowledge and control over its data. Well, you've got the points in relation to the paradox already, but our submission in relation to that is that the directive can't rationally be interpreted in this way, that if there is a searching and mark comparison system that is an automatic one, you feed in a trademark database to it, and it will then feed out whether there is identity, double identity. That is a neutral and technical and automatic processing of data, which would be, in principle, if done properly or subject to the relevant other requirements, entitled to protection. But if one does it manually, the same exercise manually of evaluation, that would not fall within the concept. The issue in L'Oreal and eBay, and indeed in Peterson, was not drawing a distinction, or it wasn't getting into the precise detail of the nature of a content review. So the court didn't need to do that kind of evaluation that arises in this case, nor take the language of its case law and apply it in that kind of context. So we don't have a clear interpretation of that concept. But in our respectful submission, to say that this would be applicable in one case and not in the other would be a very unusual and non-purposive approach to interpretation of that legislation. That is reinforced by what the court went on to say in the L'Oreal case, where in paragraph 115 on JA 761, there was reference to the UK government submissions that the mere fact that an operator of an online marketplace stores, offers for sale on its server, sets the terms of its service, is remunerated, and provides general information to its customers, which presumably would include information about the products, can't have the effect of denying it the exemptions from liability, where by contrast, the operator has provided assistance which entails in particular optimizing the presentation of the offers for sale in question or promoting those offers. It must be considered not to have taken a neutral position between the customer seller concerned with potential buyers. So what the court is getting at is really active steps and active and specific steps with respect to the goods in question. Not generalized filtering of products by reference to very general, in a large measure, content neutral, save for illegality, review. And in our submission, that approach to Article 14 is much favoured, or is more to be favoured by this approach to the case law. And I'll come on to the Peterson point in just a moment. On the Article 14 1A point, picking it up at 120, the court there draws attention to the language of the legislation, which we respectfully submit is tolerably clear here, aware of facts or circumstances from which the illegal activity or information is apparent, not should have been. In the last mention, respected sufficient in order for the provider of information society services to be denied entitlement, for it to have been aware of facts or circumstances on the basis of which a diligent economic operator should have identified the illegality in question and acted in accordance with it. And in our respectful submission, what is there meant is that not that the operator should have gone out and obtained facts from which, on the basis of which a diligent economic operator would have identified the illegality in question, but that it was in possession of facts upon which that evaluation should have been made. And that test remains, to that extent, a subjective test. And when I say to that extent, because any test of awareness that involves relative standards, so in this case, from which something is apparent, it involves an element of evaluation. has some normative element to it. But we respectfully submit that if one is reading both of the parts of that directive together, it would be very odd if this part was importing a fundamentally different approach to the test from the first part, which in our submission plainly relates to subjective awareness on the part of the undertaking.
You're talking about actual knowledge.
On actual knowledge. So what one would be saying was that on the one hand, part one of the test involved subjective actual knowledge, and part two of the test involved objective imputed knowledge, and potentially, if one follows the approach lying behind the question, knowledge imputed of specific categories of trademark rights to one or more individuals in the undertaking. And we respectfully submit that if one goes down that route, that really has gone far from the shore of what the framework is of this statutory scheme. And it's particularly far from that shore in circumstances where the starting remedy is for the operator to be subject to an effective notice and takedown. Because whatever one may say about that sometimes not being satisfactory and sometimes being the subject of over-declaration and so forth, which the court will know about, that is the primary approach, and it's inherent in the scheme of the regulation and indeed the disjunctive reference in that paragraph. So we respectfully submit that if one is adopting a coherent approach to that piece of legislation, that is the way to go. Final point on Peterson.
I don't necessarily see the disconnect. To take a completely different example, take legal knowledge, and let's suppose there's some hypothetical claim in negligence against a lawyer. Well, some lawyers will actually know an awful lot more than a reasonably competent lawyer ought to know. So actual knowledge may be far greater than that which a diligent economic operator should have known.
Oh, I accept that, but this is legislation which is setting a standard for relief from a particular liability. And our submission is not that there may not be different kinds of knowledge, indeed different kinds under each head, subjectively and actually, but that there is no real rationale for taking a different approach to those two, even though in a lawyer's situation, one would not, there may be actual lawyers who know more. So the analogy, if I may say so, may be better if one considers the actual lawyer who knows exactly as much, but no more, than the reasonable lawyer ought to have known under the second head. If there is a standard of liability that says you need to have met this standard.
I mean, I can see the argument that the facts and circumstances which you take into account under the second limb are those of which the operator was actually aware. But then when you get to what conclusion should be drawn from that awareness, surely the invention of the diligent economic operator does import some measure of objectivity into what that legal construct ought to have concluded from the facts of which the real operator was, facts and circumstances of which the real operator was actually aware.
Well, one does have to bear in mind the actual language of the legislation.
Well, except the court has invented this concept.
Oh, indeed, the court has invented the concept, but in my submission, it's not intending completely to depart from the language of the regulation, because what the regulation says is not aware of facts or circumstances from which the illegal activity or information is apparent. Apparent. And actually is apparent. And you might say...
Are you disputing that apparent means objectively apparent?
There is a standard, certainly, of whether or not something is apparent, in that, for example, just to follow my Lord Justice Lewison's analogy, if the standard of negligence requires something to have been evidently done, and it was not done, and it was evident that it should have been done, then it was objectively apparent that the notice to quit should have been filed on a given day, and the failure to do so may lead to consequences, and to that extent it is objective. But the earlier part of that is whether or not the provider is not aware of facts from which the legal activity.
Yes, well, that I understand, but as my lord says, is apparent in the way that has been interpreted by the court means would have been apparent to a diligent economic operator.
Yes, and to that extent, I think it's hard to disagree. The point of departure here, or the point of difference, I think, between us is whether or not that means that the diligent economic operator ought to have acquired additional facts.
Well, that's a different question.
Which is perhaps a different question, from which then the relevant illegality would then have been apparent.
Yes. Now, I understand the way you put it is that you know what you know, in fact. Would it have been apparent from those facts and circumstances alone to a diligent economic operator that there was something illegal going on?
And in particular in circumstances where it might be said that the more the diligent economic operator looked for material, the more it might be said against that person that they'd ruled themselves out of
well, I think the court accepts that, because it talks about uncovering illegal activity as a result of
that's exactly the point, which itself is not suggested by the court to rule out application of the regulation entirely, because what the court is saying there, and indeed could not have said if that kind of activity had ruled it out, is once you've done that, you've investigated matters on your own initiative, then you've got to take them down if you see that there is illegality, or you've got to address it in a particular way. So I've taken up a lot of your time on this because the argument is central on the e-commerce directive, and the only other point to make on that is that in our submission, the judgment in Peterson is consistent with those submissions, and you've got paragraphs 113 to 118, which I've already gone to. I don't think I need to go back to them to answer this point. So those are our points in answer both to our appeal and the respondent's notice on the e-commerce directive point.
I'm bound to say, speaking for myself, I'm still puzzled by the idea that you can use the sign, but nonetheless be technical, automatic, and all the rest of it.
That's what I was going to address next, if I may, if it's convenient, because there is a problem there, and it was a problem that my lord put to me right at the outset, which is if you're an infringer, if you, the undertaking, are an infringer as opposed to the third party being an infringer, does it follow from that automatically that you are disentitled to take advantage of
not
that
necessarily
provision?
Automatically, but in the vast majority of cases.
My lord, that may be right.
Because I think the Court of Justice has accepted that there's a theoretical distinction, but what they seem to be saying is that although there's a theoretical distinction, in practice the answer will usually be the same.
Well, we respectfully submit that that is that's not exactly what the Court of Justice was saying in Peterson in our submission.
Well, I can see that you maybe said you're not using,
Yes.
but nonetheless you can't rely on Article 14. Where I find difficulty is to say you are using, but you can still rely on.
Oh no, I understand where my thought is coming from on this. If we're not using, then we don't need Article 14 because we're not liable in any event, and the point doesn't arise. It's only in circumstances in which the mark is being used that the regulation or the directive could have purchase to relieve someone of liability. And so, to have a situation where you have a piece of legislation which is designed to provide a defence in circumstances largely where someone, if they are alerted to a relevant issue, addresses it with sufficient rapidity, then means that there is no defence because what they are doing in relation to the infringement aspect disentitles them to that in most cases. I'm sorry.
The primary purpose of Article 14 is to immunise the operator with regard to the third-party infringements.
Indeed.
So it doesn't deprive it of all effect. All it says is, if the question is not, are you exposed to liability for third-party infringements, are you exposed to liability for your own infringements? It's a bit different, isn't it?
Well, the third-party operator would never, in principle, be liable for third-party infringements. I mean, there may be circumstances one could envisage where the operator was not liable for its own infringements on the basis of primary liability, but was nonetheless regarded as secondarily liable with a third party for infringement. But one might say that those circumstances.
Yeah, but again, that's the different circumstance. So again, go back to Law and eBay, where imagine the counterfeits. So there's a plain infringement by the seller. So one of the functions of Article 14 is to immunise eBay, subject to compliance with the conditions, obviously, for liability for those infringements. Now, then you get the question of, well, what about accessory liability for the third-party infringement? And that, of course, is a different question. And in our question, it's not answered because the judge didn't find it necessary to determine whether there was accessory liability. But even if you suppose that Article 14 shields against accessory liability for the third-party infringements, you're still left with the question, why does it shield you against your own infringements?
Well, because if you are, I mean, that is, in my respectful submission, not really the right approach to the scheme of the legislation at all. Because you don't need to be shielded from third-party liability, because you don't have liability in the first place. The whole point of this piece of the legislation is to relieve someone of liability they would otherwise have, not to relieve someone of liability that they don't have. That would be, in my respectful submission, a very strange interpretation of the directive, because that would be saying that what the legislature had done was to include a piece of legislation designed to provide a specific defence to monetary remedies against a claim that could never be advanced.
Take the first example I gave you, which is the scenario where the seller is selling a counterfeit and the seller is liable. And I can take your point that if there's no liability on the part of eBay in that scenario, they don't need defence. Of course, that's right. But part of the point of this is to give them the confidence that they don't even arguably infringe. So it gives them the security to operate knowing that they've got a complete immunity against any claim of that sort.
Well, but that is, with great respect my lord, not what the directive says. It is not saying this is providing. It is there to provide merely immunity in relation to any risk of claims. And I could see, of course, my lord, that there could be.
It doesn't just do that, because it also covers accessory liability.
Indeed, but it would be very strange, and the European case law, in my respectful submission, doesn't support the notion that this is seeking to immunize a online provider only in respect of a given kind of liability for infringement. That there's nothing in the case law that
What else is the Court of Justice saying in Peterson?
Well, in our respectful submission, what it is not saying is that there is only relief from liability in circumstances where there would otherwise be no infringement. If my lord has a particular part in mind that I've overlooked, please, I should have done that. But in our respectful
What's
submission,
the paragraph you took us to yesterday?
I think the passage I took you to yesterday was 113 to 118.
It's 108, where they accept the theoretical point made by the Advocate General.
Oh, I see, yes.
Distinct question. And they go on to say, however, the fact remains that where such an operator contributes, which beyond merely making the platform available, then the operator can't be regarded as filling the conditions.
I accept that in some circumstances that may be the case. I'm not saying that there are no circumstances in which that isn't the case. But the point of difference is that in our submission, the starting point is that it is not excluding circumstances in which there may be liability. I mean, this was obviously dealing with a specific context of copyright infringement, but was nonetheless completely inapplicable. And it would, in my submission, be a very odd interpretation of the regulation to say, well, in fact, what this was doing was effectively confirming liability on the part of the intermediary, and doing so in such a way that, in the context of this kind, would mean that there was never really any incentive on the part of a right owner ever to pursue the ultimate tortfeasor, because you'd always be able to go against the intermediary in those circumstances and make it liable for its own infringements without any possible defence.
Well, what else is the court saying in the second sentence of 108? Beyond merely making the platform available. So as soon as you go beyond that, you're at risk.
Well, one may be. In my respectful submission, that is a very it's a very non-purposive approach to interpreting that part of the Peterson judgment, because what it would then do is essentially render what follows almost entirely redundant, because what follows there is all on the premise that there is liability, and indeed one would expect the court to have said, if my lord's interpretation was correct, that this really means that the case ends there. We don't really need even to look at the question of Article 14(1)(a). We don't need to look at a question of a general obligation to monitor, which they then went on to do in paragraphs 113 to 118. And we certainly don't need to make a ruling on this, because for practical purposes, once there is infringement, it is it is game over.
Well, no, because they say if the referring court were to find that it contributes beyond merely providing for a platform. So it accepts that it's for the referring court to decide whether YouTube or Arnold have gone beyond merely providing the platform, and that leaves open the possibility that it won't have done so. And so it's got to allow for both possibilities when it goes back to the national court, and that's why the paragraph 8 point is not redundant, isn't it?
Indeed, but if one reaches that point, then there isn't an infringement in the first place. But that's the whole point. Why would one ever need any of this legislation? I accept, my lord, this is not the most perfectly, well, perhaps I shouldn't accept it, that sounds impertinent. There are some difficulties in interpreting this judgment, but if one takes it as a whole, what it is not in my submission saying is because there's infringement, you don't have a defense. I mean, when I say infringement, because you are liable as potentially a primary infringer on the basis that you haven't distanced yourself sufficiently from the relevant acts. That means you don't have a potential defense. Indeed, it would be really quite surprising for that to be the case, because otherwise whether you like it or not, the restatement of the law or the development of the law in the most recent legislation would again be quite difficult to reconcile with the idea that it was there intended to provide not only a defense to certain remedies for infringement, but also to ensure that that internet providers were not disincentivized from engaging in activity that made them aware to that extent of the content on their site, because they would have to do that in order to fulfill that obligation.
We're not talking about awareness at this point. We're talking about use. Because the court goes on in 109 to talk about awareness, saying the fact that YouTube has technological measures aimed at detecting copyright infringement doesn't implicate them, so to speak. So that's a different question.
Yes, and we respectfully submit that there is the same kind of disconnect between the concept of use in or use by, in this case, Samsung in the trademark context, and such activity as would disentitle it to rely on the provisions of Article 14. Even assume that it's the case that Samsung is regarded as, to that extent, responsible, because consumers may regard one or more of the apps as in some way connected with Samsung on the App Store for one or more of the reasons that the judge gives. In all respectful submission, it does not follow from that because there is that perception, that would automatically mean that Article 14.1 was inapplicable. I mean, what that would amount to is to say that in any situation in which a online operator was liable for trademark infringement, other than those where it was only perhaps liable as an accessory, if it was liable for trademark infringement, this defense would have no application at all.
Well, I'm interested in that point because one of the problems in this area is the piece, and of course, is a copyright case concerning communication to the public. And one should obviously be careful of being too hasty to transpose everything said in the copyright context to the trademark perspective context. But are there any specific differences in the trademark context that you would rely upon?
Yes, so one is this, that if one is thinking about use on the basis of a perception of an average consumer, and that's the touchstone for liability, of a provider in respect of products that appear on that provider's site, for the reasons that we've looked at extensively.
So that was the potential distinction that Mr. Malamich identified, which is, he said, you could have a circumstance where applying the two tests leads to a different result because the use question depends importantly on the perception of the average consumer, whereas the automaticity question, if I can label it that way, is not so dependent.
Yes, I mean, to that extent, I agree with that structure of the argument. And that is realistic. And part of the reason it is realistic is this. Let us suppose that the reason that one attributes liability to Samsung under that head is because one wants to look at things from the perspective of the average consumer, for again, the reasons that we've looked at extensively. It may nonetheless be right to say that that liability for financial relief should remain with the provider of the app in question, and unless the provider has undertaken very specific activities with respect to the particular apps in question, so as to essentially make them their own. But that would not be enough to do that, to have a general monitoring or even a specific monitoring for trademarks, because that could be purely internal activity that would pick up on the relevant trademarks.
I understand that, but that's not what the judge is saying. When she's discussing use, she is saying that Samsung are actively promoting these apps and part of their advertising and attractive features of the smartwatch and all that.
I understand that, and in our submission on that, neither on use nor on the fundamental Article 14 concept is issues of general promotion of the app sufficient, because in that was not regarded as sufficient in the passage that I've just drawn attention to. General features of the site, these are attractive, or indeed even saying to developers, you want to develop things for this site, encouraging people to use an online platform, either at the side of people putting things onto the platform, or people taking them off the platform, and ensuring relevant compatibility. We would respectfully submit that's not attributing use to Samsung, and I have the submissions in relation to that, but even suppose that I'm wrong about that, that is not the kind of intervention in our submission that would disentitle reliance on Article 14.1 for all of the reasons that I've given. And were that to be the case, one would really have a position that was did render this legislation substantially inapplicable in any trademark context. And we respectfully submit that really was not the intention. It's not the way in which Peterson, or indeed any of the authorities, including L'Oreal, have been framed, and that in principle it's something that we're entitled to rely on. So those really are much more extensive submissions than I'd intended to make. They actually overlap a little bit on the answers on the other points. I think I've actually already addressed you probably enough on the use in relation to and the third party seeing the mark on watches. The only thing I would say additionally on that is these analogies with pots and wine and so forth are really not apposite analogies. What I'm dealing with is, for example, a case or something like that for a wine or some shroud that is temporarily visible, but not to a typical consumer who knows perfectly well that the shroud is not from the same origin as the winemaker. Yes, as regards use by Samsung on the bus, the consumer is not seeing any context which would suggest that Samsung was involved in that at all. Let me just check whether I've missed anything out that I need to really. Unless I can assist your lordships, my lady, further.
Thank you very much, Mr. Alexander. It will not surprise you to learn that we will reserve our judgment. You will get a draft in the usual way. It comes with a fierce embargo, which means what it says. So it can only be distributed to those on the list that's been handed to the court before the appeal began. Receipt of the draft will be your opportunity to correct our English, but not our reasoning, or to introduce new points. We would hope that in the light of the draft you will be able to agree a form of order disposing of the appeal. But if you can't agree a form of order, please make short written submissions before the hand down, and we will make the form of order that we consider to be appropriate. The hand down will be done electronically, so there is no need for anybody to attend, and don't necessarily expect it as a Christmas present.